Good afternoon. My name is Jim Townsend, and I am the director of the Levin Center at Wayne State University Law School. Welcome to today's panel discussion entitled Congressional Oversight of the Digital Marketplace, Protecting Competition, Privacy, and Truth. The Levin Center is hosting this event in partnership with the Wayne Law Review. Thank you for joining us, and I hope everyone in attendance today is staying healthy and safe in these extremely challenging times we are experiencing. I'm going to briefly describe the Levin Center and how today's panel discussion fits into our series on oversight of science and technology. I will ask Will Broman, editor of the Law Review, to share some thoughts, and then we'll get into our panel discussion. Now, just a few words about the Levin Center. Former Senator Carl Levin founded the Levin Center in 2015 upon his retirement from the United States Senate, where he served for 36 years. The Levin Center is headquartered at Wayne State University's Law School in Detroit and also has a Washington, D.C. office. The mission of the Levin Center is to advance bipartisan, fact-based oversight and civil discourse as instruments of change. In the past few years, the Levin Center has, with our partners at the Lugar Center and the Project on Government Oversight, trained hundreds of congressional staff in the techniques of bipartisan, fact-based oversight. And we have begun to bring that training to state lawmakers as well. We also support and conduct research on important oversight topics and maintain an oversight scholars listserv that quite a few people today who are with us today contribute to. And we advocate for the right of the legislative branch to conduct oversight and the vigorous use of that power by Congress and state legislatures to ensure transparency and accountability in government. We originally envisioned this gathering as part of a three-panel symposium on technology and congressional oversight that the Levin Center and Wayne Law Review had planned to host at the law school way back on March 20th of this year. That event, of course, had to be canceled due to the pandemic, and rather than wait until in-person conferences become possible, we offer today's panel on congressional oversight of the digital marketplace, which is the third and final panel of our symposium series. If you are interested in viewing the other panels on oversight and technology, please visit the events section of the Levin Center's website, where you can find video recordings of those panels. I will now turn things over to Will Broman, but before doing so, I want to thank him and his colleagues at the Wayne Law Review for their help in organizing this symposium and for their work in producing the recently published Law Review edition dedicated to congressional oversight. Will, take it away.
Thanks, Jim. On behalf of the entire Law Review and the Wayne State University Law School, we appreciate the partnership with the Levin Center and all of the great work and research that you all are doing. On behalf of the Law Review, my name is Will Broman. I'm the symposium editor, and I want to thank our editor-in-chief, Kylie O'Brien, for her leadership during this last couple of months and moving forward. I'd also like to thank Professor Regan, Slade Bond, and Alyssa DeCunha for their contributions to this latest edition of the Law Review. And I'd encourage all of our attendees to check out waynelawreview.org to download all of the latest articles. This symposium is quite timely, as I think everybody will discover, not only because of recent events in the news, but because I'm sure that the minute I just simply reference refrigerator organizers, Amazon and Facebook and Instagram will all be sending me ads for the next 2 months, asking me if I want to organize my refrigerator differently. So I think, as I said, this is an extremely important topic, and I can't wait for what our panelists have to share. To all of our attendees, we will be posting the link to the slides for you to follow along here shortly. Thank you.
Thank you, Will. Now, today's panel is intended to increase our understanding of the role of congressional oversight in exposing, analyzing, and fostering dialogue and ultimately legislation on key issues in the digital marketplace. And those issues include privacy, disinformation, and antitrust concerns. So we're asking, how does congressional oversight work in an area that is incredibly complex and politically charged? Because the substance of these issues is so important, it will be tempting in this conversation to delve into that substance and to talk about what policy changes may be needed. But we are actually here to talk about something else. We are asking our panelists to comment on what has been the impact of congressional oversight on the digital marketplace, and specifically on competition, privacy, and the truth. In other words, how is congressional oversight working with respect to these issues and the lawmaking that is or is not happening in this space? Are there ways congressional oversight can improve to enlighten the conversation, provide needed data, and make sure that voices across the spectrum of politics and society are heard? Our three panelists have a wealth of knowledge in this area and come at it from varying perspectives. I will ask each panelist to provide a roughly 7-minute presentation, and then we will hold an open discussion and question and answer period, which should run for about a half hour or until about 4:10 p.m. I will then return with some very brief concluding remarks. Members of the audience are encouraged to submit questions via the Zoom chat function, and I will do my very best to get to every question. So let's get started. First, we will hear from George Mason University professor Priscilla Regan, who has analyzed over 50 congressional hearings in the last 5 years on topics related to the digital marketplace. She has an article in the Wayne Law Review Oversight Edition listing the hearings and providing her analysis, and she is the first to do this type of oversight hearing analysis in this area. Dr. Regan has published over 80 articles or book chapters, as well as the book Legislating Privacy, Technology, Social Values, and Public Policy. So now please welcome Professor Priscilla Regan.
Thank you, Jim. And thank you for sort of teeing this up for me and identifying the 3 issues that I'm going to be looking at. So Margot, I guess next slide, or can we start my slides and let me start my stopwatch so that I can try to keep to 7 minutes. Okay, and then the next one as well. All right, so as Jim said, there are 3 issues that I was sort of tracking over the last 5 years in terms of congressional oversight. The question of anti-competitive behavior, sort of competition, which at first was defined as net neutrality, and then later as the discussion progressed became more focused on antitrust. Second was the online privacy issue, the commodification of personal data. In this area, there was discussion about the ineffectiveness or the effectiveness, but largely ineffectiveness, of industry self-regulation. And there was discussion of legislation that had been introduced, the Consumer Online Privacy Act in particular, and discussion about whether or not there was a need for a data protection agency. That came in at the very end. And then last was the question of content. The explosion of fake news, inaccurate information, biased information, which raises questions about censorship and the First Amendment. Next slide. So when we're looking at congressional oversight, and this is sort of, the academic in me, to point out some of the concepts that have been important and that I sort of used in my analysis. The first is that oversight involves here foresight. It's really sort of looking at the identification of the policy problem and the question of what are policy options. This also was more fire alarm oversight in terms of responding to particular instances, which we will see. And then 3 other issues that came into play. One thing we always want to keep in mind when we're looking at congressional oversight are questions about divided versus unified government and how partisanship came into play. Then whether or not when you have bursts of congressional oversight, and questions which are pivotal to this discussion on the technological capacity and expertise in Congress. So I'm going to go through each of the issues quickly and then have some concluding remarks. In the area of anti-competitive behavior, there were at least 16 hearings, with the largest number of those hearings in 2019. You sort of saw something of a steady rise in the hearings. In terms of committees, this was pretty much focused in the Judiciary Committee and the Commerce Committee in both the House and in the Senate, although the House was more active. The hearings I looked at, there were 70 witnesses, and a pattern we will see throughout the three issues. The largest majority of witnesses were coming from companies and industry-related groups. Next slide. And then for each of the issues in the article, and I'm really not going to have time, I think, to do this here, but I sort of looked at the dynamics of what was under discussion for either one hearing or a set of hearings. So for the question of competition, I looked at the House Subcommittee on Antitrust of the Judiciary Committee, and they had held 5 hearings. And as you can see, they're quite thorough in their investigation of the different practices that come into play in terms of competition. Next slide. And then online privacy, 19 congressional hearings. Again, started off strong in 2015, less activity in 2016, which was sort of true across the board, and then an uptick in 2018 and 2019. Here, the Senate was more active, especially in the 2018, 2019. And here you've got more congressional committees involved than you had in competition, banking, commerce, judiciary, oversight and government reform, all held hearings. Witnesses, I identified a total of 65 witnesses with, again, as I said, more witnesses from companies and industry groups. Here, what was different, you saw witnesses from the FCC and the FTC, both of which had certain jurisdictions over online privacy. Next. The dynamics here, there were basically, as I looked at the hearings, 3 tracks that could be identified over the course of the 5 years. One was responding to new technologies. What's going on with big data? What are the challenges and what's the capacity of big data? And the Internet of Things. So both of those as sort of new technological issues came into the fore. Then specific privacy invasions, the Uber breach, obviously Facebook, Cambridge Analytica was a big issue. And then the issue of policy options. Senate Commerce Committee, as I said, had a series of hearings that were quite substantive and really quite good and on a bipartisan basis. Next. Content control, 21 hearings over the 5 years, consistent over the time period. Here that it was evenly split between the House and the Senate in terms of numbers of hearings, and a different group of committees to some extent were involved: Commerce, Judiciary, Intelligence, and Foreign Affairs. A fair number, 86 witnesses, again, more from companies and some academics and think tanks, a bit more in this area, and some from government as well. Next. Dynamics here, you've got the key one was the high profile hearings on Russian interference in the 2016 election. Next. All right, so in terms of conclusions, We see for all three issues serious and sustained congressional oversight. A total, as was indicated earlier, of at least 56 hearings, drawing a total of 221 witnesses, mostly from industry. Facebook, Google, and Twitter, not at all surprisingly, appeared as witnesses for all three issues. As I indicated earlier, this was really fire alarm oversight rather than police patrol. In terms of divided versus unified government, I didn't identify a pattern here. Antitrust, the Democratic House got more involved than the Senate. Privacy, the Republican Senate had gotten involved, although there had been, I know, work prior to 2015 on the House side. And on content, both the House and the Senate were involved, and this was the issue that was most partisan in tone. And we see different bursts of activities, especially for the tail end, the 2018-2019 time of the 5 years I was looking at. And then the final slide. No, not quite yet. Okay. In terms of, we don't really have specific measures of effective oversight, but some of the things to think about are the degree of partisanship. I really sort of talked about that. The impact on policy is going to be, I think, an important one. I think in the competition area, the hearings have very effectively teed up the issue for after the 2020 election. To a certain extent, regardless of who wins, that's going to be an issue. And we also have the Justice Department now involved as well. Online privacy, I think there's action is likely to happen on that as well. There's a fair amount of agreement on what type of legislation would be needed. Content control, we continue to see increased public awareness, although there's not really agreement here on what to do. Another concept here to look at is the question of fragmentation. Anti-competitive, you got two key committees. Online privacy has been quite fragmented in terms of the congressional oversight activity, but the Senate Commerce Committee seems to be taking the lead, and I expect will continue to. Content control, we've got the highest level of fragmentation. Now the last slide. Okay, so two overall takeaways. One thing you obviously see is the heavy reliance on industry input. And what you hear in a lot of the hearings is the relative, in comparison to the industry, lack of expertise outside industry and the lack of expertise in Congress. This is something the committees are obviously aware of, and we are likely to talk about. So I will end there, and I know I've gone over the 7 minutes, so I apologize.
No problem, Professor Regan. Thank you so much for those comments. We will hold questions until we've heard from all three panelists, and we'll now turn to Slade Bond, who serves as Chief Counsel at the Subcommittee on Antitrust, Commercial, and Administrative Law, which is chaired by Representative David Cicilline. Slade oversaw the recent 2-year investigation of antitrust issues involving Facebook, Google, Amazon, and Apple, including 5 hearings, which culminated recently in the publication of a 450-page majority staff report. We have asked Slade to talk about the process that the subcommittee followed to conduct its investigations. What were the objectives of the investigation, and how was that decision reached? What were its biggest challenges? How bipartisan was the investigation, and why, in the end, did the final product become a majority staff report from the majority? To hear answers to these questions and other questions, please join me in welcoming Slade Bond.
Thank you so much for having me, and I really appreciate that kind introduction, Jim. It is an absolute pleasure to join today's important panel on congressional oversight of digital markets. As Jim mentioned, my name is Slade Bond. I'm the Chief Counsel of the House Antitrust Subcommittee. We recently produced a majority staff report following a 16-month investigation that I'll be speaking about today. I'm speaking in a personal capacity and going to focus on the process of the investigation, and I'm happy to take any questions as well. Before I begin, I'd really like to thank Elise Bean for her tremendous leadership in this area generally. The Levin Center has been and is an excellent resource for congressional oversight, and Elise has been a terrific resource during our investigation. She, of course, was a longstanding staff director of the Permanent Subcommittee of Investigations, which was chaired by Senator Levin, and certainly set a high bar for us as we approach this area. And I'd also like to thank Jim and the Levin Center and Wayne Law for having me today. So just to begin, I'd like to sort of really follow up where we left off and focus on the role of Congress in conducting congressional oversight generally, and then move to the investigation that we recently conducted. So Congress really has two primary constitutional mandates when conducting oversight. First, and this is the one that's usually discussed the most, it is a constitutional mandate to conduct oversight of the executive branch. And this role is primarily to ensure compliance with relevant laws, oversight of agency effectiveness and performance, and to investigate fraud and abuse. And that's something that, Elise certainly did in her previous capacity following the financial crisis, and it's certainly something that is ongoing today and something the Judiciary Committee has been very active on this administration as well. And secondly, and this is where I come in, Congress's mandate to conduct oversight of private sector companies too. And this is less obvious, but it relates to its core authorities in terms of legislative action. So it's Article 1 responsibility to legislate in response to public concerns involving interstate commerce. And this is particularly true where there are significant and harmful events that affect the public interest. So as I mentioned, in the wake of the financial crisis, the Permanent Subcommittee on Investigations conducted a groundbreaking and historic investigation of Wall Street and released a comprehensive report less than 2 years later. So the financial crisis is a good example. More recently, the fatal crashes of the Boeing 737 MAX airplane. That was a report that was released by the subcommittee or the Committee on Transportation Infrastructure during this year. So it's also important to develop expertise in an area, and congressional investigations really give Congress the ability to dedicate sustained attention to an area, to develop an oversight record, both through hearings, but also information requests and interviews, and really to cast light on matters that are important to the public. And one of the sort of fallacies of thinking about oversight as only existing from federal enforcement agencies is that those are generally non-public, whereas Congress has an important public role and gives the public an opportunity to weigh in as well, which is an important counterbalance to some of the industry inputs that Dr. Regan mentioned in her presentation. And this is also important because it's effective where there are immense information asymmetries between private sector companies and Congress, such that just having a hearing is probably not going to escalate some of the major issues, or you'd have to have a series of hearings, and even sometimes that's not enough. And so information requests can really be complementary to that function. And then finally, there can be dual oversight functions that are also important. So in the case of the digital markets investigation, the TNI investigation into the Boeing crash, the financial crash investigation conducted by PSI, there can be a dual component where you're really conducting oversight of both the executive branch and private sector companies at the same time to kind of figure out how did this happen? Was there regulatory or enforcement failure? In addition to how are the markets developing and what are some of the reasons things are happening in the way they are? And that's also something that's very difficult to do in the absence of a formal investigation. So I want to turn briefly to the digital markets investigation that was covered so far as part of today's panel. Back in June 2019, the House Judiciary Committee announced a bipartisan investigation into the state of competition in digital markets. The purpose of the investigation was to document competition problems online and to evaluate whether the current antitrust laws and enforcement levels are adequate to address these concerns. And this investigation was really started because it was clear that there are 4 companies that are increasingly serving as gatekeepers of commerce and communications online. And this gatekeeper role, rather than the companies themselves, is really a source of tremendous power and concern. and the opportunity to abuse that power, which is an area that we conducted extensive oversight into. The public has a right to understand not just how these companies are using or potentially abusing their power, but whether there are paths forward to fixing these problems. So Congress, as I mentioned, has a unique role in this area, and our investigation has shown the institution continues to play an essential role in identifying and addressing any legislative gaps in the law today. So as for our investigation, this was the most comprehensive antitrust inquiry conducted by Congress in decades, literally decades. So I have one of the 1955 reports here, and this used to be something routine that Congress would do. In the age of typewriters, they would really document and outline concerns that were core to economic interests in the economy. It would be the steel industry or telephony or even soybeans and agriculture, things that were really core to U.S. economic interests. And the antitrust laws are an interesting area where it's a statutory body. It's not case law. These are laws that were written in the era of railroad tycoons and have been considered durable for a great period of the 20th century. And the point of this investigation is really to examine whether or not they were durable for the 21st century. So this investigation was really about identifying any legislative gaps and fulfilling our constitutional and institutional mandate to conduct oversight in that area. So just one minor correction, we actually held 7 hearings. We had 5 in 2019. We had an additional 2 this year. Actually 3. Yeah, so 8 total. These covered, as they mentioned, really specific topics involving the digital market, such as privacy and data collection. We also held 17 briefing and roundtables with more than 35 experts and stakeholders through the Antitrust Subcommittee, sent 93 requests for information to both the dominant platforms as well as affected third parties and antitrust enforcers, and conducted hundreds of hours of calls, meetings, and briefings. We interviewed nearly 250 market participants, third parties, and former employees. And after 16 months, we concluded the investigation in part and completed our final report, which ended up being about 450 pages long. I was saying earlier that it broke the printer when I tried to print it out at work. We did not set out to write this lengthy tome, but that's really where our congressional record took us in terms of documenting some of the concerns we found. One of the interesting things was that, again, we didn't plan on this, but we did most of this work during the pandemic. We had our major 6th hearing with the CEOs of these 4 firms, where we did a lot of prep work remotely, and that was certainly an interesting area of experience, not something I had been involved in before. Obviously doing doc review and other forms of oversight via laptops is suboptimal, but we did our best to ensure that the report was as comprehensive as possible. So I'll do a brief outline of the report, and I know I'm running a little short on time, so we can get into some of these things in the Q&A. But the report has separate sections to deal with findings about the market power of the 4 dominant firms, and includes a series of recommendations for potential areas of legislative activity by the subcommittee in Congress. And so these primarily focus on methods for restoring competition online, strengthening our antitrust laws, and generally ensuring strong enforcement. As the chairman of the full committee and the subcommittee noted in their forward to the report, the committee, of course, reserves the right to request additional information as necessary as part of this process, but the report was really intended to serve as a capstone to provide the public with an opportunity to read about some of the issues that were raised during the July hearing and some of the competition concerns that we identified generally during the investigation. So with that, it's my pleasure to turn it back, and I'm very happy to discuss all of these issues during the Q&A. Thanks.
Slade, thank you so much for those comments, and we will look forward to getting into more depth during the Q&A. Finally, we will hear about what it is like to be on the other side of a congressional investigation, specifically when you are charged with representing an organization that is responding to a congressional inquiry. For insight into those matters, we have turned to Alyssa DeCuna, a partner at WilmerHale, who has represented digital companies in dozens of congressional investigations over the last 10 years. So we want to know, what are the most significant challenges for digital companies facing congressional investigation? Are there ways that the process can be improved so that companies protect sensitive information while still providing full and forthright responses to congressional inquiries? So for answers to those questions, please help me welcome Alyssa DeCuna.
Thanks, Jim, and thanks to Elise and the Levin Center and Wayne State for hosting us today. This is an important and timely topic. I've enjoyed hearing the remarks of my co-panelists, and I think there's a lot to think about here. As I think my co-panelist remarks made clear, this is a really challenging area right now for digital companies. There's an unprecedented range of issues facing them. And there's really a bipartisan focus on a lot of these issues. There's bipartisan focus on their business model, on competition issues, as highlighted by Professor Regan. For social media companies in particular, there's a similar bipartisan focus on the ways that they moderate content. We're in the middle of an election and a pandemic, and there's a high level of concern over disinformation. These are complex issues, they're interesting issues, and Congress has been at the forefront of investigating them and providing oversight here. So I'll spend the bulk of my time talking about congressional oversight, but before we dig into that, I think it's important to remember that all of these oversight efforts are occurring against a backdrop of very active state attorney generals, very active agency investigation, agency rulemaking, civil litigation, and investigations by regulatory bodies around the world. So a private company's strategy in responding to Congress has to take into account all of these other proceedings, all these other fora. You can't be in a position of sending a representative that says one thing before the US Congress and then says another thing before the UK Parliament or before a UK regulator, for instance. So it's important to have a high degree of coordination both internally for these companies as well as between their external counsel. And for most companies, this requires a truly holistic strategy, thinking about how to approach all of these issues in a coordinated way. But focusing on congressional oversight, which is what we're here to talk about today, I think the first observation I'd make is simply the sheer number of entities that are looking at tech issues today. By some counts, there are as many as 250 congressional committees and subcommittees. And that's, of course, before you get into individual caucuses or other subgroups that may exist that can send letters on their own. And, of course, individual members can send letters without any committee affiliation at all. And quite a few of these committees and members have been focused on tech companies over the past few years. There have been a number of high-profile hearings. Slade led some of those, featuring company CEOs. There was one just this week before the Senate Commerce Committee. And while executive level hearings tend to attract the most press, the most coverage, it seems like I haven't done a full count, but it seems like there are hearings on tech issues just about every week that Congress is in session. From my perspective, having been working in this area for about a decade, the sustained pace of hearings and inquiries has been truly remarkable. And it's just further evidence of the broad range of issues facing the industry. And it doesn't look like it's going to let up anytime soon. When news breaks about a major issue, you see this really spring into action in a surprising way. A company can receive dozens of inquiries from Congress literally overnight. And those inquiries can take the form of requests for information, requests for documents, or briefings, or of course testimony. When you take into account that some of the letters that committees will send have 20 plus questions, additional subparts, any hearing could have hundreds or even thousands of questions for the record. This adds up very, very quickly. So I think the corollary to my first observation about the sheer number of entities is the lack of a streamlined government approach when you're talking about responding to congressional inquiries can really create significant burdens for the companies that are responding. They might be facing competing deadlines. They might be facing competing or even duplicative information and document requests. It can be challenging, and it can require companies to invest quite a bit of resources into responding, even when there are kind of live issues and fact development is ongoing. In addition to the vast number of committees, there are, as everyone knows, 535 members of Congress. They each have their own constituents, their own issues, their own geographic regions, and things resonate differently in different parts of the company, in different parts of the country. So you see this play out as companies have to think very carefully as they're responding about the different issues that are important to each member. So as you see these kinds of competing demands on company resources that usually require helping with fact experts, outside counsel, devoting quite a few resources when there are live issues, this can really be a challenge. And that's one place where we enjoy parachuting in and helping our clients, but it's also a challenging thing to explain to our clients. You can contrast this with, for instance, the approach taken by the Department of Justice, where you could be dealing with different offices, different entities within the department, but private sector targets can reasonably expect the department to speak with a more or less unified voice. There's no such expectation on the Hill, and that's one of the things that makes the oversight world both interesting and challenging. So one of the things that flows naturally from this, the broad number of entities and the broad number of issues, is that there are just an incredibly wide number of issues that technology companies have to think about as they're interfacing with Congress. On the slide that's up right now, you can see just a few of the issues that have come up for digital companies over the past few years. If you're a senior executive called to testify, you have to be prepared to address any and all of these issues, as well as being reasonably well versed in pending legislation and the pet issues of any lawmakers on the panel. Normally when you talk about pet issues, this is a bit of a euphemism, but as we saw, for those who might have seen the Senate Commerce hearing this week, it actually took a literal turn. I think it was Senator Johnson who asked Twitter CEO Jack Dorsey about a false tweet in which someone accused him of strangling his neighbor's dog. It's a bit of an unusual and perhaps humorous example, but it just shows that when you are a senior member of management called to testify, you really have to be prepared to address just about anything and everything. If we can move to the next slide, slide 5, note some of the top areas of focus right now. We didn't separately list out section 230, but of course that comes up in connection with several of these topics, perhaps most notably in connection with bias allegations. And that's certain to be an area of focus for months and perhaps years to come. On the question of election integrity, tech CEOs have already committed to testifying in late November. There will almost certainly be a number of questions around the election at that hearing from both sides of the aisle. Companies are in the process of making decisions around when they will and will not accept ads around political issues. I think we'll continue to see developments in that area. Antitrust, both Slade and Priscilla have touched on this. The DOJ lawsuit against Google has been dominating the news for the past few weeks. This is quite obviously going to be an area of focus for quite some time to come. Data security, obviously privacy is a major issue, unlikely to decrease in importance anytime soon. China and TikTok, this is an area where we've seen Senate Judiciary take the lead. TikTok has thus far, I believe, avoided sending any witnesses to participate in hearings, which is interesting, an interesting choice, but they are unlikely to be able to continue that approach as they come under US ownership. Bias, we used to refer to this as conservative bias issues, conservative bias allegations, but it seems like there's plenty of outrage to go around. And again, this was on display quite clearly this week before the Senate Commerce Committee, as both sides of the aisle seem to be equally upset about the ways that some of the tech companies moderate the content appearing on their platforms. So in wrapping up, I'd highlight something that Jim previewed for us. This is an issue that doesn't generate a lot of press coverage, but it's of critical importance to the private sector entities that are turning over documents and information in congressional inquiries, and that's data protection. As we've touched on, Congress has a truly unique power to obtain sensitive information from private parties through its oversight efforts. This is a unique part of its legislative capacity and is well recognized, but it also raises some concerns in that today's Congress, including the 13,000 individuals who work for Congress, who are employed by Congress as staff members, It stores an unprecedented amount of electronic data. So depending on the documents that are being produced and the inquiries at issue, this can include everything from personal identifying information, trade secrets, company business and pricing strategies, manufacturing information, health records, even national security type information. For many companies, this is truly the secret sauce, so to speak. And it doesn't take a lot of imagination to come up with scenarios in which a hack or inadvertent disclosure could result in huge amounts of information being made public in a way that can move markets, in a way that can be truly disastrous for companies and private sector targets. So this is something that's top of mind for a lot of our clients and something that we've had to think about. We've discussed this with oversight staff in the past, and we generally can reach accommodations on behalf of our clients that allow for more secure transmission of information, whether that's providing access to documents through a data room, whether that's providing information through briefings instead of through documents, or simply by looking for other ways of providing committees with the information that they need while protecting the business and privacy interests of cooperating companies. So the last thing I would touch on, we've got a quote on my final slide here. This is just an interesting development for those who follow the oversight world, is that there was a interesting statement about privilege in a court opinion earlier this year. If we can go to the next slide. This is a quote from the Trump v. Mazars case, which dealt largely with oversight of the executive branch. But there was an interesting quote around privilege. So most congressional committees take the position that attorney-client privilege does not apply to their investigation, as it's a court-made doctrine as opposed to a constitutional doctrine. But this opinion casts doubt on that practice, which is an interesting turn of events. I think as a practical matter, it might not make a huge difference, as staff and private parties are often able to negotiate around any privilege issues and find other ways of getting staff the information that they need without compromising that privilege or exposing the company to issues on their litigation front. But it's certainly an issue to track over the next few years. So with that, Jim, I'll turn it back to you for Q&A.
Melissa, thanks so much for those comments, and you've set us up beautifully to go to Q&A. We have about a half hour to cover, have open discussion and cover some key questions. Let me kick things off by asking all three of you to comment on the large number of hearings. It came as sort of a surprise, I think, certainly to me and probably to many others, that there were over 50 hearings in the last 5 years on these issues involving digital companies. How would you characterize this level of oversight? Has it been productive in your mind? Has it educated members of Congress and the public? Has it moved the issues? Or is it, or is the system being overwhelmed and these issues are so complex that we're not making a lot of progress? So go in any order you'd like, but I'd love you to just sort of give us your general thoughts on how this is going in the last 5 years.
I'll take a stab at it. I think it varies somewhat by issue. I think on the privacy issue, progress has been made, and I think, as I indicated earlier, that there's pretty close to a legislative sort of compromise that is in the works. The issue that I think that the competition issue has been, as was pointed out by the report, has been thoroughly investigated. I think right now, sort of the DOJ getting involved is kind of stealing some of the thunder, possibly, may work together with Congress on this, but it'll be interesting to see what happens there. As Elisa was pointing out, this is, it increases the number of entities and the number of arenas in which discussion is going on, which may just be more noise. And I think on the content control, it's important. It's raised the issue for the public, but there is not agreement on this issue. And this is going to be a really hard one, in my mind, for to grapple with.
Yeah, happy to follow up on that too. I think, and I tried to get into this briefly in the opening remarks, I think where there are emerging areas of either the law or the economy, the type of sustained attention that we're describing is really necessary to dig into an issue. And I'm reminded of, Congress approaching broadcasting, in the early 20th century and, ways to address, concerns and novel economic areas that culminate in really like watershed laws like the Communications Act. And this is something that Congress does periodically. So in the 80s, in the wake of the breakup of Ma Bell, there was considerable oversight of that consent decree and legislative activity that followed even that, culminating in the 96 Telecom Act, which had repercussions even to today in terms of oversight activity that Dr. Regan described in terms of like net neutrality. So that's absolutely something that is critical in terms of developing sort of that muscle memory about a new area of the economy. One thing that came up earlier is, the bipartisan nature of investigations. I agree strongly that, it is important to be inclusive of both parties. One of the things that's sort of lost in the conversation is, elections have consequences and the party that is in control gets to dictate the agenda. And so to the extent that, Democrats have been in the minority, there has not been a ton of activity on antitrust beyond like really important areas like healthcare. And this Congress, there was really a assertion of, areas that have been somewhat underexamined over the past decade and even longer than that as part of, the Democratic House. And so that's why it's not surprising to me to see a lot of activity now where there hasn't been historically. But having said that, I think that investigations are generally much stronger when they have bipartisan cooperation, not just because it's important to, proceed and sort of expand, the areas of inquiry, and that's always healthy. But again, if the idea is really to do an investigation and then follow it up with legislative activity, unless you want it to be a partisan project, you want to make sure that both parties have the same information inputs, are receiving the same areas of concern, developing the same muscles in terms of like, okay, so this is a real issue, this is not an issue. And that way, that really informs your legislative agenda in a healthy and productive way. So I think finally, there are just going to be some areas where, Congress is of divergent views, right? Luckily, I don't think antitrust is one of those. I think it's an area where, on the conservative side, there's an agreement that free markets really depend on, removing restraints of trade. And on the progressive side, there's just a longstanding view that the concentration of economic power ultimately manifests in the concentration of political power, and that's corrosive and harmful from a democratic perspective. And additionally, there are concerns about other sort of, corrosive effects of concentrated power generally. So it's fortunately an area where I think there's going to continue to be bipartisan cooperation. I got a lot of flack early in the Congress when Senate Judiciary beat me to having a hearing on antitrust and tech, because they did. I mean, we had a really robust agenda relating to drug prices and healthcare that was a cornerstone of the For the People agenda, and something that we did a lot of work on before we even got to the investigation. And that's a pretty good indicator of how these things kind of are symbiotic in terms of building congressional attention and activity long term.
Yeah, and I think what I'd add, Jim, is you mentioned hearings, and that is certainly one thing. Professor Regan probably actually has the statistics on this, but at least my sense is that the pace and frequency of hearings has picked up quite substantially over the past few years. The Senator Levin, the Levin Center namesake, was a master of the multi-year document-heavy investigations, right, with a very clear long-term investigative plan that involved interviews over a number of time. And obviously, Slade, perhaps you and Chairman Cicilline have inherited that mantle a bit, but I think those kinds of investigations are really nowadays more the exception than the rule. We're seeing quite a few more hearings that are not preceded by the same kind of document-heavy investigation. So from the perspective of my clients, I'm not sure whether that's better or worse necessarily, but it is different, and it requires a different kind of strategy and a different form of engagement.
I want to touch on the issue of congressional capacity. All of you really touched on this a little bit, but I want to probe it further, which is, this is an incredibly complex area, a very technical area that Congress is trying to deal with. How do you think Congress has been doing in the last 5 years in terms of stepping up to the challenge of dealing with these technical and complex issues? And do you have some thoughts about maybe how this might go better if Congress hasn't really been meeting the standard. And again, that's kind of for all of you. I don't know, Professor Regan, maybe you should start.
Yeah, I can start on that one. And I don't know whether this was mentioned. I spent 5 years working for the Congressional Office of Technology Assessment, OTA, which was disbanded in 1994. And while I was at OTA, I worked on 2 reports that resulted in legislation. One was on electronic surveillance, which was helpful to the congressional committees and to Congress as a whole in crafting the Electronic Communications Privacy Act of 1986. And then a report on, at the time, was computer matching, and resulted in computer matching legislation. So I'm biased here, and I'll admit that. I think that the timing of getting rid of OTA was just, so ill-timed, it made no sense. And that there's definitely a need for more congressional capacity here. And this is something Congress is well aware of, and has taken steps internally, largely on a committee by committee basis, to shore up that expertise. But there have been 2 recent reports, one from the Belfer Center at Harvard and one from the National Academy of Public Administration, that have done a really good job, a thorough job of sort of investigating where expertise on technology is lacking in Congress, and how different options for shoring up that kind of expertise. So I think there's a need for that, not just in this area of digital marketplace, but I think climate change is another example of that as well. That one of the common refrains is that legislation shouldn't stifle innovation, and we need innovation, and that sort of can slow any discussion to a virtual standstill.
And I'll pick up on that. I think it is fair to be a harsh critic of congressional oversight. Historically, there's not been enough of it. In the tech area, there's been substantial, public discussion that where it has existed, it has not been very effective or responsive to public areas of concern. And that was really one of the, reasons we did something as dramatic as a 16-month investigation with, just really extensive document requests based on extensive amounts of public reporting and, tremendous, it was 1.3 million documents, right? So that's tens of millions of pages of documents that we had to pour through. And, that's not something anyone signs up for voluntarily. In terms of the decline of oversight, generally, I will point to Elise's departure from Congress as potentially part of that. But I think this is a skill set that has to be learned. And, one of the reasons why we did, a public investigation where we started out with very public requests was to normalize the process of, committees really digging into these issues. Now, one of the points that was just made is that resources are scarce. And I really do believe that if we had a body that, would report up these types of things, Congressional Research Service does a really tremendous job, and they were very helpful in terms of the investigation, in terms of, some background materials, but like in terms of sustained expertise where you have a go-to person that is studying these issues year over year and is in their job regardless of who's in power, and able to, build that body of expertise. That is really just important. And, we had to substitute that by having a technologist on the subcommittee. We were able to bring in a Tech Congress fellow this year, Anna Linhart, who had tremendous expertise in this area and really complemented, kind of a skeleton team of lawyers that, everyone's got blind spots, right? So it's good to be able to augment that where possible. But if there was a sustained, area of support in that capacity, I think it would be very net positive overall, particularly, and this kind of goes back to the information asymmetry problem, right? So like these companies, are very complex, very powerful, I do appreciate that there's been an increase in interest, but these are also trillion-dollar companies that can deal with, very small congressional requests. So to the extent that you have a countervailing source of information that's not industry-driven, I think that's very healthy for the Congress generally.
Do you think, I mean, just to touch on that issue quickly, among the three buckets that Professor Regan, specified, obviously, Slade, you and your subcommittee did a tremendous amount of work on antitrust matters. But among those three buckets, antitrust, disinformation, and privacy, is any one more is oversight playing a larger role, or does it have a larger role to play in any one of those issues versus the others?
Yeah, and it's interesting. I think antitrust is a lot harder to grasp, right? So that's kind of, with privacy, I think people get it, inherently, they understand at this point, like data collection has these ramifications, the advertising model, you are the product. That's something that people didn't realize a decade ago, now they do. With antitrust, it's still, we're building out that sort of, common understanding of what the antitrust laws, and kind of debunking this concept that it's like this giant in the hilltop that comes down every 30 years when there's a major antitrust lawsuit, right? But yeah, in terms of the overlap, we think that there is considerable overlap as it relates to the digital marketplace, and that several of these firms are advertising-driven companies, and inherently that involves privacy questions. So at our third hearing, we examined the role of competition in data collection, and whether or not privacy and competition are an either or whether or not these are things that you can have thoughtful ways to address at the same time, and that's been part of the conversation. But one last thing I wanted to point out is that there are committees of jurisdiction here, right? So the House Judiciary Committee has core jurisdiction over the antitrust laws, and oversight authority over the Federal Trade Commission, Justice Department, in terms of their antitrust enforcement program, whereas Energy and Commerce has jurisdiction over the FTC's consumer protection program. And so you'll just see, different approaches and visions in terms of, both legislative and oversight activity in response to that. So a good example is the Cambridge Analytica issue, where that, triggered a bunch of requests, bunch of hearings, and I think Energy and Commerce did a fantastic job of conducting that hearing. And you saw a really sustained level of attention from their members, and a lot of coherent questioning. And that's something that I think is a reflection of they have core competence over consumer protection. So that's not an easy area to conduct oversight, but certainly one where they can effectively do so. So,
Alyssa, I want to bring you into the conversation. What comments do you have about this? And then I want to ask a question of the two of you, of Slade and you.
Yeah, a number of the issues that we're facing are very complicated. They're challenging issues. I think we've seen, in our investigations, Congress bring in expertise where needed, and we've also seen people just work really, really hard to get up to speed very quickly. So I don't think we've found that to be a particular deficit necessarily. I think Slade highlighted some of the resources that staff and committees have at their disposal, and another one that we've seen come into play is the use of secundees from agencies, who can bring with them some of that institutional knowledge and have expertise in the issues. So it's always a learning curve around some of the specifics, and the technologies are changing every day. So that's something that's consistent for everyone in this space.
In your experience, and I want to tap both Slade and Alyssa, your experience in terms of these big tech companies, when they're being called into a hearing, or when they know an investigation is getting underway, do these tech companies collaborate? Do they come together and try to come up with a strategy for how to deal with an investigation like this?
I mean, I think when you're talking about the very, very highest levels on antitrust policy, so much of this plays out in the public square. You can see the difference highlighted in the testimony of the CEOs this week on Section 230, right? These are hard questions. They affect, even when you're talking about a large piece of legislation that's designed to function in a uniform way, they do impact each of these individual companies in a different way. So you can see them almost developing these positions in real time.
So you don't think they're coordinating, or in your experience, is there some dialogue between them? Again, antitrust is kind of a weird one to talk about that in that context, but in any context, in any of these issues, are they kind of coming together to sort of get their story straight, or at least try to coordinate what their response should be?
I mean, no formal dialogue that I'm aware of, but you can see even in the back and forth on the policy positions that are being taken, everyone's working this out in real time and are reacting to changes on the ground. I think when one company takes leadership in one area and making a change, other companies take a look at what they're doing and evaluate if that's the direction that the industry is moving. So it's a very dynamic area. We're seeing lots of changes every day. These are hard issues, and as I've observed, I think these companies generally want to do the thing that's right for both public policy, their customers and consumers, and obviously make sure that they're meeting Congress's expectation and the regulators' expectation of them.
I would disagree a little bit.
Okay.
I do think that and I don't want to get anyone in trouble on this panel, but I do think that at times there can be strains on the Joint Defense Doctrine or North Pennington as it relates to coordination around oversight requests, testimony, things like that. There was somewhat of a public element to our investigation as far as one of the companies initially did not want to testify and sent a very public response to us that was in the New York Times before it was in my inbox, I think, and certainly outlined several points that if there wasn't coordination on, then there was a lot of sort of parallelism in terms of similar positions. And I would just say that I think that this is an area that Congress, it's kind of like countervailing, power, but I think agencies and committees can do better at that, right? So committees can probably be better organized in terms of requests and sharing of information. And internationally, there's lots of activity here, and that's sort of value add too. But I would also just say that, I keep going back to this, but going back to the information asymmetries issue, there's so much institutional knowledge that's built up in years and years and years over these investigations where, I have law firms with really talented attorneys like Alyssa who have this skill set, and there's just a much higher degree of turnover in public service. And so sometimes that institutional memory can be lost, and, that sort of really does have a drain overall in terms of, we dealt with this issue 15 years ago. Now we have to deal with it again today, and you just don't really have that, sort of, tool in the toolbox to draw from. So that's unfortunate.
Let me pick up on that thread. We have a question from the audience that I want to put first to Professor Regan. There was a Rules Committee hearing not long ago that really highlighted the overwhelming kind of content and paperwork burden that comes across on a lot of these issues. And so I'm wondering if you've looked at any of the modernization, Congressional Modernization Committee recommendations, which, if implemented, would maybe help raise the tech IQ for Congress.
I haven't really dug into that, but I think one aspect of this, in terms of sort of the number of requests that come to Congress, where Congress is seeking information from the companies, and Elisa's the recommendation that that the committees only seek information that's necessary to an investigation. Part of the problem here, as you delve into the specifics of the issues and take something like AI, artificial intelligence, they're not sure. I mean, the congressional staff are not sure what information is relevant always. So I think there's that tendency sometimes to cast a wider net than might be necessary. Another point that I want to make is that many of the congressional staff, most of the congressional staff, tend to be lawyers. And as Slade pointed out, the committee hired a sort of a technology fellow for the investigation, and a number of committees have been doing this. The FTC has hired tech fellows as well. It's really the kind of expertise that would help Congress is in this area, in all three areas, are people who have a sort of multidisciplinary background. And there's a number of graduate schools that are turning out really highly qualified people who understand the technology. They've got technology background. They've got policy background. They've got, in many cases, ethics becomes important here, and behavioral economics and understanding of sociology. So that sort of multidisciplinary perspective, I think, is what is needed in the congressional environment, and that has been lacking, but would be really important. And those people have a better sense of what information is going to be relevant.
I want to shift the focus a little bit because we don't have we still have some time, but not too much, about 10 more minutes before we have to sort of wrap things up here. I want to talk and hear your perspective about how cooperative digital companies have been in faced with these investigations, because Alyssa, your presentation brought up the issue of common law privileges and whether those do or do not apply in a congressional investigation. And it reminded me, investigations come in a lot of flavors, and I think the audience would be interested to sort of get a sense of how does a congressional investigation differ from litigation or another kind or an investigation brought by the executive branch. So question one would be, how much cooperation has there been? Has it been cooperative or a little more of a fight? And how do the rules differ, and how does sort of the approach differ in a congressional investigation versus these other kinds of investigations?
Well, perhaps I'll let Slade comment on his perspective as to whether the companies have been cooperative or not. One thing I can say from my experience is one of the reasons I enjoy the area of congressional oversight is because there is an opportunity for a dialogue around these issues. It's not, in comparison to civil litigation where you might be trading views via motions practice or heated letters or something of that, and it's very adversarial. It's just kind of the accepted nature of the game. I think there is an opportunity to have a conversation, to find out what the policy priorities are of the member, of the committee, even of the staff, and what it is that the information that they need, and talk together about how we make sure that they get that information. And I like that there is a certain amount of flexibility. It's not simply a subpoena response where you turn over your documents. There could be documents. There could be bringing business people in to give briefings. There could be site visits. You can have this kind of open-ended dialogue about what it is that's going to help the committee and the staff and the member achieve their goals.
Slade?
Yeah, and I just want to pick up there. One of the sort of features of our investigation that was kind of unfortunate due to the pandemic is we just weren't able to conduct a number of interviews and depositions that we'd hoped to, and that was sort of a reality of. I remember we were on a call with Wilmer, and I think it was the Friday, not the 13th where like everybody went into quarantine, but the Friday before then. And I was like, I think Menlo Park I don't think anyone's there anymore. And, we're sort of all dealing with this in real time and trying to figure out, what's reasonable and, in terms of like pursuing your oversight goals versus what's unreasonable and burdensome. And, we tried to sort of navigate that, but I don't want to name and shame any companies. I think that their report kind of speaks for itself. You can kind of read between the lines in terms of, specific areas, but I would call attention to page 8 of the chairman's forward. Talks about this issue. It says, although the companies provided substantial information in numerous documents, the subcommittee declined to produce certain critical information and crucial documents we requested. And it sort of makes a couple of institutional observations about that. And then I would just sort of, this is a free resource for the public. It's called When Congress Comes Calling. And you have chapter 6 here, common law privileges. Do not shield witnesses from complying with committee information demands. And so that is just an area of disagreement between industry and Congress. But, Congress, it's a court-made doctrine, privilege, and it's one that committees, recognize on a case-by-case basis. But I think generally Congress is right in, trying to seek any information that's necessary to inform its oversight goals. And, I'll just say that in terms of expertise, it's not just that these are complex markets; these are extremely complex companies that are, core to the economy. And so the idea that a single information request is going to cover everything that you could potentially need to really understand that is kind of farcical. And to Lisa's point, you really do need to conduct, interviews and phone calls and speak with relevant executives, and both inside the company and outside the company. And I do think there's a shortage of technologists that are sort of integrated into, Congress and the agencies generally, but that's not an excuse. And, I'll just say that sometimes you need lawyers to argue with other lawyers, and that's an important thing too. So, with that, I'll just encourage people to read the report. It's lengthy, but I hope at least informative.
Well, we are running short of time. I do want to ask one last kind of overarching question, which of all three of you, and if you could be relatively brief because we are running short of time, but did you have a moment in any of the hearings that you witnessed over these last several years? Was there one moment in any of these hearings that really stood out to you? So maybe Professor Regan, we'll start with you.
I guess the classic one, of course, is the Mark Zuckerberg hearing on Cambridge Analytica. That in terms of the public interest and in terms of revealing a lot about the congressional process, as well as revealing a lot about the issue itself.
So, for me, we had a moment in our hearing with the CEOs where we went to a third round of questions, which is, somewhat unprecedented. And it was sort of a indication of just how much the members had done their homework and were ready to talk about those issues and ready to dig in on issue after issue after issue. And, in terms of content, not just antitrust, there was a discussion of what are some of the effects of having, dominance beyond economic injury. And so, it was just a really gratifying feeling to I kind of felt the car go into sixth gear at that point and really take off in terms of getting into issues that the members were really excited about and engaged on and really enjoyed talking about. And, kind of one of the challenges is that people back home don't necessarily send someone to Congress to take on antitrust issues. And so the ability to sort of weave in issues that, constituents really care about and members, can talk about back home, that's a really gratifying experience. That's my own personal favorite.
Great. Alyssa, you get the last word on your favorite moment in a hearing.
Well, I think I alluded to one of the moments that has quickly climbed the ranks for me that happened this week when Dorsey was asked to comment on the tweet about Senator Johnson's neighbor's dog, and I could just see that look across his face where it's like, oh, the lawyers didn't tell me about this one. And it really gives me some new ammunition when I tell my clients that they literally have to know about Congressman's pet issues. But Professor Regan highlighted the first time that Mark Zuckerberg testified, and I think one of the things that stands out to me about that hearing was the sheer scale. If you look back at the photographs from that day, the photographs taken from Mark's perspective, like standing behind Mark and just looking out at the sea of cameras, the sea of members. This is obviously pre-COVID days, and we could all pack in there, and it's just remarkable the scale of what we're talking about and what it actually is like as a company representative to be standing before all those people.
Well, I think you've highlighted the scale and the stakes involved in these issues, and the important role that oversight is playing and will play in how we move forward on these issues. That is pretty much all the time we have. I want to thank Dr. Regan, Slade Bond, and Alyssa DeCuna for doing a terrific job as panelists and really shedding a lot of very interesting light on these issues and how oversight is operating in this space. With a minute, I'll try to summarize a few things that I heard and that were presented just to kind of wrap this up. Certainly the number of hearings and the breadth of those hearings and the generally bipartisan nature of the work that's going on certainly stands out. Not that it's all bipartisan, and that it certainly there are some substantive areas of disagreement where it matters around state preemption and right of private action, some other things that definitely get the parties on different pages, but there doesn't seem to be as much of a partisan divide or as much of a divide around divided or undivided government. There's a lot of reliance on government, I should say, on industry expertise, and probably not enough in government, and certainly it appears not enough in Congress. So there's perhaps some room for reform and for some shifting of resources around that. Certainly the issue of needing to preserve information security is one that doesn't get a lot of attention, but one I think that was definitely highlighted here, and one I think people were happy to learn about. and the fragmentation. There are a great many committees and subcommittees that are working on these issues. And even for large companies, I suppose that can be a challenge, certainly for the people that are representing them. And then, we continue to have a disagreement about whether common law privileges apply to congressional investigators. So many issues. I'm afraid we didn't get to every question, but I think we had a very lively discussion. I do want to thank a couple of my colleagues, beginning with Elise Bean, who directs the Levin Center's Washington office. She did a fantastic job putting this panel together and really making this happen. I also want to thank Margaret Lepere, as well as Ben Ike from the Levin Center, for their fine efforts in working with our panelists and partners and helping make sure the world knows about this, knew about this event. And finally, I want to thank all of you for joining us today. There is a recording that will appear of this event on the Levin Center's events section, so please go to that. We will be sending everybody who attended this event a very brief 3-question survey, just asking you to evaluate today's event, and that helps us do our jobs better. Finally, I want to thank all of you. I wish everybody a good evening. Remember to vote if you haven't done so. And as a friend advised me yesterday, stay positive, but test negative. Good evening, and thank you very much.
Thank you.